When Matt called me, he said there's a lot of questions in the area about agricultural irrigation, and we're observing quite a bit of growth in the amount of agricultural irrigation. We're seeing a lot of these large facilities. And so there's this question about what does that mean in terms of how it's affecting Michigan's water resources. And so I told him that I'm not a hydrologist, I'm an economist, I do public policy work, and I can't talk about water in rivers or water under the ground in any particularly intelligent way. But what I can talk about is what the state is doing to protect the state's water resources as part of its responsibilities under the Great Lakes Compact. So that's what I'm going to talk about. So just a quick overview of what I am going to give you a little bit of information on. I'm going to talk a little bit, as in one slide, about the growth in agricultural irrigation in Michigan. Then I'm going to talk a little bit about the Great Lakes St. Lawrence River Basin Water Resources Compact to give you some context for the stuff that Michigan is doing as a state. I'm going to talk about the state's water use program, which is its implementation of the compact. A little bit about water law, because it's a really critical piece of this, and it's also connected in some ways to sort of a fundamental misunderstanding of what's going on with the state's program. And then I'm going to finally end up with a little bit about what I see as some opportunities and challenges that we face as a state in terms of the way we're managing our water resources under the current policy environment that we're in. So if I use jargon or language that you're not familiar with, let me know. If it's a detailed question that's going to take a detailed answer, let's hold it to the end so I can be sure to stay on track. But questions of clarification we can take as we go. All right, here's my one slide about what's going on with agricultural irrigation in the state. This data comes from the work that EPA has to do to register large quantity withdrawals. Now, the agricultural irrigation withdrawals are generally registered through Michigan Department of Ag and Resource and Rural Development. But the data is compiled by DEQ because they have to make an annual report to the legislature on what's going on with the program. So this breaks out what's going on with agricultural irrigation over 4 regions. Can you see the legend in the back? Southwest Michigan, Central Lower Michigan, West Central Lower, and the thumb. So that's what the graph is. These years at the bottom are program years. Yeah?
Is that both surface and groundwater?
This is both surface and groundwater. Thank you. And these program years would be the fiscal years for the state, so 9-10, 10-11, 11-12, 12-13, and our most recent year 6 is 14-15. These are the 6 years since Michigan began to formally implement the program that was created by legislation passed in 2008. All right? Yeah?
The thumb is heavily agricultural, but it has the smallest amount of water withdrawal. I don't understand that.
It has much less irrigation than the southwestern part of the state, and there's some growth in the central part of the state. And here we're getting into hydrology stuff, but if you think about it, there's a lot more drainage in the thumb, and there is some interest in irrigation. The other thing that's going in the thumb is that water resources are not as easily accessible or plentiful as they are in other parts of the state. And so there's a combination of things that make it more likely to see irrigation in some regions than the others. This is the number of irrigators, agricultural and others, largely golf course is the other category, that have gone to MDA, RD, or DEQ and said, we want to put in an irrigation system. This is the number of individuals that have asked for a well or surface water withdrawal above a certain size. I'll get to that. And I just want to point out, look at year 4. Year 4 is we saw a huge spike in the number of agricultural irrigation registrations in that year. You'll know what happened in crop year 2012. These are the irrigation systems that went in after crop year 2012. All right? And then you'll see the line starting to flatten out again. That means that the number of requests each year since that have dropped some. All right, let me give you a little bit of background information on the Great Lakes Compact because it is very contextual. I don't have to tell any of you that there's been talk for years about what would happen if Great Lakes water got siphoned off to somewhere else in the country that really needs water. And you probably saw this billboard driving down the highway, different places in the state, where they were looking at these different states that were water thirsty, and you know California still is. And so what happened, even though there had been agreements among the Great Lakes states for years about how to protect the water in the Great Lakes from diversion, they hired a bunch of legal experts. The story goes they hired Western water experts to do the work for us, and they got the best they could get, so that when the Western states wanted water experts, the best ones were taken, because the Great Lakes already had them. And what they told the Great Lakes states was, you need a formal compact if you're going to protect the water in the Great Lakes, and you have to act around the water of the Great Lakes the way that you want other people in the Great Lakes to act around the water in the Great Lakes. If you're going to make the argument that Great Lakes ecosystems are fundamentally dependent on keeping the water in the Great Lakes, you as a state or a group of states have to make sure that you are making sure that the water-based ecosystems that are critical in the Great Lakes are being protected by what you do. In other words, you have to treat every state equally. And that comes out of the U.S. Constitution's Commerce Clause, actually, as it turns out. So there was a whole series of talk, and then in 2007, 2008 was when the 8 states, Michigan was in 2008, and then U.S. Congress ratified the Great Lakes Compact. This is an agreement between the 8 states and the U.S. federal government. There's a parallel agreement between the 8 states in the U.S. and the U.S. government and the 2 provinces in Canada and the Canadian government. And that agreement, that binational agreement, mirrors the agreement amongst the 8 Great Lakes states in the U.S. What the Great Lakes, St. Lawrence River Basin Compact did was it was an agreement amongst the Great Lakes states that they would inventory the water resources. Some of the states had already done this, Michigan had not. So what do we have in the way of surface water resources? What do we have in terms of groundwater resources? Monitoring the significant withdrawals of surface water and groundwater that could potentially have an impact on the amount of water available in any system, and what those withdrawals would mean in terms of the impact on water-dependent ecosystems. So those are the responsibilities. And then doing the water conservation that's necessary to make sure that the withdrawals do not negatively impact the Great Lakes ecosystem. Those are the responsibilities that the 8 states committed to, and so that's the work that Michigan started doing as early as 2003, because we didn't have anything. 2003 was when the law was passed that initiated that inventory process. So for Michigan, it was a 5-year process to get the water use program in place. We were the only state in the Great Lakes that had no program related to large water withdrawals. We had the Safe Drinking Water Act stuff that related to municipal supplies, but any other large quantity use generally was not affected or managed or monitored in any way. Another reason why Michigan made this kind of comprehensive response to the Great Lakes Compact, and I will say, we were the only state that did the whole implementation body of laws when we adopted the compact. All the other states adopted the compact, and then they've been piecemeal trying to figure out how to implement it. So Michigan did the hard work up front. And one of the reasons was because we were seeing a growth of water conflicts in Michigan that have raised some concern about how the state was managing or not managing the water resources in the state. You will all have been familiar with the Ice Mountain conflict up in Mecosta County some years ago, but that's not the only kind of conflict between groundwater and surface water users that we saw, because down in the southeast corner of the state, there were some situations where dewatering quarries dropped the water table and municipal wells went dry. All right, and then we were seeing some well-to-well conflicts, and this was in the Saginaw Basin area, where we did in fact see some large wells that, when they were pumping seriously, were affecting smaller wells in the area. And the state has had a program for several years through Department of Ag and Rural Development to mediate those particular situations. So there were conflicts in the state as well. So basically what that means is, beginning really before 2003 all the way up through 2008, is that there were 3 fundamental policy questions that were being debated in the state, and there were advisory councils that were created by the governor and the state legislature to work with stakeholders around the state and look at these questions. The first one was, how much water is there? And so beginning in 2003, that inventory process started for surface water and groundwater. The second one was, how can withdrawals of surface water or groundwater negatively affect water-dependent ecosystems in the state? So they were looking at the science of how does that interaction between water and the environment take place. The third one was, well, if we admit that water is an economic resource for us as well as an environmental resource and we're going to use it, the question is, if it's going to affect ecosystems at all, how much effect are we willing to live with? Let's figure out what the standard is that's okay with us as a state, and we'll use our water, but we won't cross this threshold that tips us into some territory that we don't want to go. So those were the three questions that were deliberated over a number of years, and there were a number of steps that were taken to sort of address those. I'm going to get in the weeds a little bit, but not too much, to get a little bit more information here. But first, let me just say that the outcome of all of that was a water law passed in 2008 to implement the compact, and essentially what that meant was, starting in 2008, all proposed large quantity water withdrawals are screened. And they're screened to determine the relative risk that they will have a negative impact on water-dependent ecosystems. This is groundwater and surface water. The work that was done early on by the councils looked at the physical relationship between groundwater withdrawals and surface water flows, and they did that work. There was a lot of good modeling work that was done, and so they are screening all proposed large withdrawals against that work that they've done to look at the impact. And there was, in the state law, established these thresholds for withdrawals of surface water and groundwater. Anything below that threshold was deemed to cause an adverse resource impact. That's compact language. Every state can define adverse resource impact as it wants to. All right, but in Michigan, we're screening to avoid those kinds of negative effects. Yes, sir.
Could you give me an example of a large quantity water withdrawal in a local area?
All right. The examples of large quantity water withdrawals in the state generally fall into these categories.
No, can you give me a specific example, something that I can relate to around here?
Your city water supply,
Okay,
most large agricultural irrigated operations.
okay.
So those are the kinds, and so it's 100,000 gallons per day or more. All right. So in agriculture, we're talking about a 70 gallon per minute pump on a well. If you're on a house, who's on a well on their home? How big is your pump? 5 gallons a minute?
No,
5
it's
gallons
more
a
than
minute?
that. I've got a deep well. It's a lot.
Okay. But you can see 50 and 70.
Yeah.
Right? Okay, so agricultural, golf course irrigation, some other types of irrigation, public water supplies, industrial facilities, if they aren't on public water supplies, will sometimes be large enough to go over this threshold. Fire protection, if they're not pulling it out of the public water supply. Many areas don't because they don't want to use the treated water for fire protection. Lake augmentation, we've got quite a bit of that in the state where groundwater is pumped out to keep water levels in lakes at where they want them. Mining and dewatering, I talked about that example down in the southeast. A lot of thermoelectric power generation in the state, bottled water plants, and also then geothermal facilities can be large enough, or units can be large enough that they will pull enough groundwater out to qualify for needing to do this. Here's the way this breaks down in the state. Between 2009 and 2015, this is the relative size of the number of requests coming from these populations. So you can see that irrigation is by far the largest segment of large water users in the state. All right? And this is strictly large in the term, not necessarily in the amount of water. We're talking about the number of people going to the state and saying, I want to register my withdrawal. All right? And these, yeah.
Do you have a slide that shows the amount of water broke out like that by volume?
No, I don't. But I could get that information for you. Agriculture is not, thermoelectric is the largest. Right? And then
I think public water.
public water supply is the next, and then irrigation is the next after that. There was another hand.
When water's taken off for irrigation and it's sprayed on the land, does very much of that water return to the system as it percolates down?
The research says that by and large, when you're talking about irrigation, consumptive use, which is water that doesn't go right back in, is anywhere from 95 to 98% of the water. All right, I'm going to need to move on. I don't want to cut you guys off, but I'm on the clock here. All right, so let me get a little bit deeper. This is the science that was done to figure out how to set the thresholds for how much water could come out of a well, come out of an aquifer, come out of a stream before we saw some negative impacts. It was all based on what was going on with the fish in the streams that were going to be impacted. Why fish? It's not about the fish, it's because fish were the indicator of environmental impact. And that was because in Michigan we had good science that was done many years ago looking at the relationship between stream flow and fish populations. And that was the best science we had, so they used fish as an indicator of the neighborhood. All right? It wasn't about the fish. And what they said in the state law was, we're going to limit the negative impact on characteristic fish populations when we look at these withdrawals. So withdrawals are screened, and they basically say what percent of the index flow of a stream can be taken out, either through groundwater pumping because of the hydrologic connections or through direct withdrawals, how much of an index flow can be moved, and how much of a reduction in the density of characteristic fish populations are we willing to live with. And so as you might expect, as you take out a larger proportion of the index flow, you're going to see a larger impact on the population density. That's what these graphs mean. All right? And the state set up a system whereby they would evaluate proposed withdrawals based on how big of a risk. If you were looking at dropping it down to somewhere within this region, it was relatively low risk. But every time a withdrawal is screened, it potentially removes a larger proportion of the surface flow in the water system. And for every stream reach in the state, there's a number established that if you drop below that number, by statute, you're creating an adverse resource impact. And that's where withdrawals are cut off in the aggregate. Yes, sir.
Is that also different for seasons?
The thresholds were established based on year-round, 20 years of year-round data.
Mm-hmm.
All right, and there's 11 different types of standards based on the size of the stream, the temperature of the water. So that's the differentiation that you see. But it's an annual sort of and the differential in flow is accounted for in that. So what's happened since this program was established, this will tell you how many individual approvals have been done each year, and you'll see what happened in year 4. Let me talk about these two different things. There's a 2-stage process by which these withdrawals are screened. The first one is there's an online tool that people who want to make large withdrawals can go into and put in all of their information about their proposal, and that tool will take a look at this particular picture or the numbers associated with it for that location and make a determination of where we are relative to the proportion of water that's available to be withdrawn. If that screening tool says you're good, then you're good, and you register your withdrawal right then. All right? But the state was conservative because this is all done based on modeling work that the scientists have done, and so they said we're going to sort of be very careful, and if ones are sort of iffy and we're not sure, we're going to create a process of site-specific reviews, right, where we go to the site and we collect as much data as we can, and we get sort of on-the-ground information, and we establish whether there's going to be a possible adverse resource impact. So in other words, we're not going to rely on the sort of models that are sort of a little bit removed for us. We're going to actually go to the field and see what's going on. And so what that means then is that you've got this many withdrawals that have been approved over the years of the program, and between this time period, 09 and 15, there have been 20 applications denied because it was assessed based on a site-specific review that they would, in fact, cross that threshold that had been set for that particular location. There are still some others pending, but so far there have been 20 that weren't approved. Yes, sir.
Have there been any that were approved that after the fact had an adverse effect?
I'll get to that. All right. What I want to get to now is that there's a fourth policy question that was not addressed in the early legislation or in the early work that was being done, to the extent that all of the rest of the program, all the nuts and bolts were done. And that is, if we accept that water is a finite resource, and if we've got a threshold because we're protecting ecosystems, water-based ecosystems, and so we're setting some amount of that resource aside for ecosystem protection, how do we make the decision about the remaining water and its allocation How do we decide how the water that is available to be withdrawn and used for various purposes is divided amongst these different competing uses? All right, now here's what I'm going to step back just a minute and do a little law for you. I want to do a quick primer on water law. Water rights in Michigan are established according to court-made law, and this started with the beginning of the country and then the beginning of the state. So it's through the courts, court-made law, that water rights are established and protected. But just as with every other type of right that we have as citizens of the U.S. and of Michigan, there are certain restrictions based on how we can exercise those rights. And so essentially the water use program is regulation of water withdrawals as an exercise of the police power of the state. So in other words, the state is vested with certain abilities to protect residents against various kinds of things. That's called police power. And regulation of water use is part of that responsibility of the state. So the rights come out of the court, the regulations come out of state government. All right? The rights before the 2006 law, when we first really started looking at this, the screening didn't start till 2008, but they started really trying to assess the impacts in 2006. So the rights before that law was passed was that surface water rights said if you own property adjacent to a body of water, you got the right to use it, but it's subject to the rules of reasonable use and correlative rights, which means that other people have the right to use it too, and you cannot do anything that unreasonably affects the ability of other owners, riparian owners, to their reasonable use of the water. In the back.
Could you tell me how much water is approved to be withdrawn for fracking?
So it depends upon the operation. No, I've got all these numbers in my head, and so I can't, I'm sorry, I can't. But I will tell you that the amount, this is what I do know, that the amount of water that's pulled out for fracking is less than the amount of water used on MSU campus on a daily basis.
I understood it was about 21 million gallons per frac.
I'm sorry?
21 million gallons.
Again, it depends upon the size of the operation. I'm sorry, it's just not my thing. So that's surface water rights. Groundwater rights. If you own land, you own the right to punch in the well and use the water. But so does everybody else who owns land. So your rights to use water are restricted by you can't negatively impact the ability of another landowner to use their water for reasonable use. All right? This term reasonable use is really important. It's something that the court decides. All right? So what if someone's use of surface water or groundwater is hampered by somebody else's use of surface water or groundwater? Either they work it out or they go to court. All right? That's how rights are defended in this country, through litigation. All right? That's what was the situation before 2006. So what was the situation since 2006? I just want you to see that the only thing that changed on these two slides was the word before went to since, and the word was went to is. All right? But the fundamental structure of water rights in Michigan did not change as a result of the water use policy. What does that mean? It means that if we've got people competing for a limited amount of water, they're going to have to work it out as people who have shared responsibilities, shared rights with respect to the water. So essentially, water rights in Michigan, crap, this isn't working. I'll tell you what this slide says. It says that Michigan is not a prior appropriation state. Western states are. That means first in time, first in right. Michigan is not a first in time, first in right state. All right? There's a certain amount of water available. That water has to be shared by the people who have legal rights to the water for reasonable use. And again, that's something that if it's questioned, it's a question for the courts. Because the water is shared, scarcity is also shared. So when there are limits on the amount of water, everybody is essentially going to have to cut back because everybody still has a right to use some of that water. That's different from the western states, where if there's a shortage, the guys that had their permits early on, they're good. And the guys that just got a permit, they're bad. And that's what's been happening in California. They've been dropping off as they go up the list in terms of the amount of time that people have had their permit. That's not the way it works in Michigan. One of the reasons that we saw a lot of wet, and I just want to address this real clearly, I think one of the reasons we saw a lot of large withdrawals go in when we saw them go in right after the program started and then right after 2012 There were clearly risk management issues, all right, for agriculture especially. But there's this misunderstanding that if I get my well in the ground and I get my water, I'm good. And that's not how it works in Michigan, all right? Because the guy next to you has got his well and he thinks he's good, and the woman over there has got her well and she thinks she's good, but if water tables drop, you're all sort of in the same boat. All right, so what did the statute change? If the rights didn't change, what did it change? And I compare this to a bank account. And you know how they used to anyway, they may still. You have to, certain minimum balance in your checking account, right? Or else you have to pay a monthly fee, or you don't get interest, but of course that doesn't matter anymore because nobody gets interest. But there's a required minimum balance for bank accounts, just like there's a required minimum balance for the water in the state of Michigan to be taken out of the ground and taken out of streams. And that minimum balance is put in place to protect water-based ecosystems. So that minimum balance was created in the state in order for the state to implement the Great Lakes Compact. So that's what's different. That means that when there's scarcity and people have to deal with how they're going to share water, they're no longer talking about scarcity when we're almost out. They're talking about scarcity at a higher level of flow in the streams because the flow is going to be maintained to protect those ecosystems. So let me go back to this question. If water is a finite resource and some part of it is now set aside for ecosystem protection, how do we decide how that water is going to be shared amongst competing uses? You don't have to read this. I just got it up for those of you that are sort of policy wonks like me. This is language right out of the state statute. And what it says is that all persons who are making large quantity withdrawals are encouraged to establish a water users committee. And then that water users committee will work together to think about long-term planning and other kinds of issues related to water withdrawals. In the event that DEQ determines that by reasonable scientific evidence that an ARI is occurring, then those water users are to come together and figure out amongst themselves how to implement changes in the way they're using water to make that adverse resource impact go away. In other words, they've hit that minimum balance, they've dropped below it, and as a group, because we're a reasonable use correlative rights state, as a group, they're responsible for deciding how water is going to be allocated. Yes, sir?
This may be a question inviting too long an answer, but how is that minimum balance determined? And is it at what level? It's resource by resource? It's
Stream reach by stream reach, there's over 5,000 of them in the state, and this work was done for every one of those, all right, using historical flow data. I'm sorry?
How about groundwater, lake water?
Yeah, it's all in there. Well, lakes are not. Right now, it's just groundwater and streams. They're working on lakes now.
And so aquifers are actually have minimum balances, or these are determined as you go? Or?
The stream flows have a minimum balance, but groundwater affects streams. And so all the accounting is done based on the stream water, and there's work done to establish the impact of groundwater withdrawals on the streams that they affect. So that's how it was done. All right, so the bottom line here is that the legislature didn't want to decide who's got priority use. They said, we're going to let the water users decide. And so they put this stuff into law that says if there's a problem, the water users are the ones that need to come and figure it out. It says that DEQ is supposed to facilitate this process of the water users coming to agreement on these voluntary measures. It also says that no large quantity users are required to agree with that and to follow it. It says that DEQ, if they can't get agreement, DEQ can propose something, but nobody's required to follow that either. All right? What does that mean if there's no requirement that anybody actually do that? Let me talk you through a little bit of a cycle here. The process that we're looking at right now is this. There's a legally available amount of water that's established. It's based on what the relationship between surface water and groundwater. We've got this long process where all the withdrawals are screened and approved. If they're not approved, then you saw the numbers. There's been 20. There's, I think, 30-something pending right now. All right? Well, what happens? We know we're living in a new climate world, and we don't know what's going to happen with stream flows. The models are uncertain for us in Michigan. But there's also data problems, and we had a situation in Kalkaska County, I think, it was one of those up there, where they were doing all their work based on stream flow for a stream that in the data was a perennial stream where water always is there. When they got there to do the site-specific review, they found out it was an intermittent stream. There's not water always there, so there's no fish. So they had to go back and recalibrate all the work they were doing, which meant that the wells that they thought were connected to that stream weren't. They were connected to another stream. Those are cold transitional streams. They will take very little withdrawal before those cold water fish, those cold transitional water fish, are negatively affected. That meant it bumped the neighboring stream into an overdrawn position. And so they're trying to figure out how to deal with that situation. All right? So stuff happens, whether it's changes in the climate, whether it's a long-term drought. Stuff happens, and at some point, thank you, I just have a trigger thumb. At some point, you got a situation where cumulative withdrawals exceed the limit of what's acceptable. The law suggests that water users are going to get together, all right, and figure out how to deal with that situation and make that adverse impact go away. Fundamentally, that means there's got to be less water in the aggregate taken out of that system. And that those voluntary agreements are about how you're going to make that situation happen. But there's a corollary situation here, and that is we're going along and we're reviewing all these proposals and they're being approved, and then suddenly one's not. Well, as a landowner, I have a right to access water from below my property. But what I don't have, because of the exercise of police power in the state, is the right to negatively impact water-based ecosystems. All right? Under common law, I don't have the right to negatively affect my neighbor's reasonable use. It doesn't mean they might get to keep what they're using, but they have to have access to water. I can't take that away. But by the same token, if my use is reasonable and it would be deemed so by the courts, I have that right to exercise it. What does that mean? It means that we're fundamentally in the same situation. The denied applicant can go to the other water users in the area, seek agreement on how they're going to change what they're doing so that this new person has access to the water that he or she is legally, under common law, entitled to. All right? It may not be as much as this person wants, but they're entitled to some amount of water because of their ownership of property. So in the best of all possible worlds, they all get together and they figure out how they're going to make space for this person. Now, the research I've done, I got to tell you, doesn't make the existing water users happy. The attitude has been, we were here first. But remember what I said, that's not how water law works in Michigan. Yes, sir.
So you're suggesting that this is not going to end up, if there's disagreement among the water users, a regulatory solution, it will be a judicial solution?
No, I'm not suggesting that. But think about the administrative cost associated with enforcement actions and the cost out of our pockets. Anybody who's in a court of law with litigation costs. So what I do in my research is look at this question of what are the relative costs to water use of working together versus going down this path. And there's two scenarios. One is, what if stuff happens and we're below the minimum balance and the state's got to do something about it? It's not clear from the state's water law, the statute, what the state can do. It's not clear whether there's some sort of enforcement action that they can take or whether the state will actually have to go to court to alleviate the situation. It's a big black box right now and we just don't know. And one of the reasons we don't know is because we haven't gotten there yet. All right? And they're trying to figure out, the current Water Use Advisory Council is trying to figure out how do we manage these situations to avoid all of these critical costs. All you have to do is look at the Florida, Georgia, Alabama situation going on with the Flint, the Chattahoochee, and the Apalachicola, and you know there's a lot of money that's gone down the drain in those three states fighting over water. And I just think that there are better ways that we can handle it if we can figure out the dynamics of that agreement work. The same thing is true if we've got somebody who the state says, sorry, I can't approve your withdrawal. The amount of water being pulled out of the system has to go down before the new person can be let in. So the same situation applies. If we can't work that out as water users in order to enable everybody who has the right to reasonable use to exercise that right, we're possibly looking at litigation. I can't get my neighbors to use less water, I'm going to court, and I'm going to get the judge to make them use less water. Yes, sir?
You know, in the past 10 years or so, has there been subsidies or cost share available for irrigation systems?
NRCS does have water available for some sorts of irrigation practices. I can't tell you specifically what they are. I know that some of them aren't appropriate for Michigan. They're more for western states. And I do know the one thing that they don't cost share is anything related to power. Because one of the thoughts was if we could get agricultural irrigation off the surface water systems and into groundwater systems, they have less of an impact. And also we don't have diesel tanks that are right next to streams, but there's no cost share money to switch from diesel to electric. I know that much. But the folks at NRCS could answer that question for you about what specific practices that there are. And there's a big project funded by USDA in the southwest part of the state, and I can't tell you for sure whether Berry County is part of that, but they've got a lot of money to cost share water-related practices, both water quality and irrigation. The St. Joe River, Friends of the St. Joe, and the Conservation District down there, and the Three Rivers, the Southwest Michigan Planning and Regional Planning Commission, those are the people who have that, and MDARD can also answer that question for you about that. That's special money that has been set aside for the southwest part of the state. All right, so I told you that I fundamentally think that if we can figure out how to manage the resource users can figure out how to manage this so that the agencies and the courts don't have to do it, then I think it's going to be cheaper in the long run in a lot of different ways. But the work I'm doing looks at what makes that work or not work, what makes it likely or not likely. And the kinds of things that are important is if there's evidence of interdependence amongst users, we get that we're affecting one another. We need to have that. It depends on the number of users, because the more people you have that have to negotiate, the harder it gets. And now you got costs associated with negotiation that just ramp up. It depends upon the homogeneity of the interests and the people that are working together. If they all sort of have the same interest and the same goal, it may be easier than if you've got a real diverse group of people. It depends upon the social relationships amongst the people that are involved. It depends upon the norms that guide the activity that they undertake as a group or choose not to. It depends upon what kind of power the local authority has. And when I'm talking about local authority here, I'm talking about the power granted that water user committee by the statute and by the regulatory agency. And then supportive sanctioning rules. That just means that DEQ has rules in place that enable these water users to do what they need to do, all right, and make it work for them. But there also have to be incentives in place. And the issue, remember I said we don't know what's going to happen if we run up against one of these problems? It's because we haven't had it happen yet. And if there's no clear costs of just doing something, then there's an absence of any sort of incentive to do anything differently, and this stuff will just end up in litigation. And that may be the way that we find out the answer to some of these questions, to clarify some of these questions. But it just hasn't happened yet, so we're in a real gray area in what's going on with the state's law. Before I finish, I want to do one other thing, and that is talk to you about one other kind of group that can be established under the statute, and it specifically refers to them as Water Resources Assessment and Education Committees. In the statute, it lays out specific entities that basically the state is saying, you guys can get together and do these kinds of things, or any other things that you think you want to do. But you know what? This kind of group is no different than a Water Resources Council, a watershed council, conservation district could initiate something like this. Any sort of community group that's got an interest in water management can come together and do this sort of long-term look at what do we have, how do we think it should be used, how do we deal with potential conflict, how do we avoid potential conflict, how do we plan for those kinds of things. This is something that the community can do. Now, it doesn't affect the rights to water that we talked about earlier, but it does affect things like, for example, if a community has a zoning map that has a bunch of residential development in areas that are water rich, but they also want to grow their agricultural industry, wouldn't it make sense to put your residential development in your zoning map in an area where maybe they don't need as much water because they're either on city water or they're on private wells, but not as much, and you set that other area aside for agriculture so that you know you've got the relationships in place. So that's the kind of assessment and planning that I'm talking about that can be done at the community level. So here's my shameless plug. That's the kind of work that Extension can help communities with around the state. If there's interest interest in working with watershed councils or water resources groups or any sort of community group that wants to come together and start looking at issues of water management and water assessment and planning, that's something that we can work with you on if that's something that's of interest.